Delaware has a well-organized lease termination framework that provides clear procedures for both landlords and tenants. The governing law is found in the Delaware Residential Landlord-Tenant Code, Delaware Code Title 25, Chapter 55. And it's one of the more detailed state landlord-tenant statutes in the Mid-Atlantic region. If you manage rental property in Delaware, the process is structured, and the courts expect compliance with every step. Let's start with no-cause termination. For month-to-month tenancies, Delaware requires either party to provide at least 60 days written notice before the termination date. 60 days is one of the longer no-cause notice periods in the country, twice the 30-day standard used by most states. This gives Delaware tenants substantial time to find alternative housing, but it also means landlords need to plan well ahead when they want to end a month-to-month arrangement. The notice must be in writing and must be delivered by one of the methods authorized by the statute: personal delivery, certified mail, or first-class mail. The 60-day period runs from the date the notice is properly served, not from the date the notice is drafted, so timing the delivery carefully is essential. For fixed-term leases, the lease expires at the end of the agreed term. Delaware does not require additional notice for the natural expiration of a fixed-term lease unless the lease itself contains a renewal or notice provision. If the tenant remains after the term expires and the landlord accepts rent, the tenancy converts to a month-to-month arrangement subject to the 60-day notice requirement. For week-to-week tenancies, Delaware requires 7 days' notice from either party. Now let's cover termination for cause. For non-payment of rent, Delaware has a specific process that requires the landlord to file first, and then the court provides notice to the tenant. Under Section 5502, the landlord files a complaint for summary possession in the Justice of the Peace Court after rent is 5 or more days overdue. The court then issues a summons, giving the tenant a specific period to respond. Delaware doesn't require the landlord to provide a separate pre-filing notice demanding payment. The filing of the complaint and the court summons serve as the notice to the tenant. This means that technically, a Delaware landlord can file for eviction once rent is 5 days late without first sending a demand letter. However, the 5-day grace period is statutory. The landlord cannot file before rent has been overdue for at least 5 days, even if the lease doesn't include a grace period. Once the case is filed, the court schedules a hearing. At the hearing, the tenant has the opportunity to pay the full amount owed, including rent, late fees, and court costs, and the case will be dismissed. This right to pay and stay at the hearing functions as Delaware's primary redemption mechanism. If the tenant pays at the hearing, the tenancy continues. If the tenant doesn't pay, the court enters a judgment for possession. Here's an important detail. Delaware limits how many times the tenant can use this pay and stay remedy. If the tenant has been through the non-payment process and redeemed at the hearing 3 times within a 12-month period, the court can deny a 4th redemption and enter judgment for possession even if the tenant offers to pay. This limitation prevents chronic non-payment while still giving tenants a meaningful safety net for occasional financial difficulties. For lease violations other than non-payment, Delaware has a detailed framework that depends on the nature of the violation. For curable violations, the landlord must provide written notice specifying the breach and giving the tenant a specific period to remedy the situation. Under Section 5513, the notice period for most lease violations is 7 days. If the tenant cures within 7 days, the notice is void. If the tenant doesn't cure, the rental agreement terminates and the landlord can file for eviction. For repeated violations of the same type, Delaware allows the landlord to terminate without providing another opportunity to cure. If the same or a substantially similar violation occurs within 12 months of a prior notice, the landlord can serve a notice terminating the rental agreement without a cure period. This 12-month look-back provision prevents tenants from cycling through repeated violations and cures. For violations that pose an imminent threat to health or safety, including criminal activity, drug-related offenses, and conduct that creates a clear danger to other residents, Delaware provides an expedited pathway. The landlord can serve a notice giving the tenant as few as 7 days to vacate without an opportunity to cure. For the most serious situations, including the manufacture, distribution, or possession with intent to distribute controlled substances, the landlord can pursue immediate eviction. Delaware has specific statutory provisions addressing drug-related activity on rental property. Under Section 5513, if a tenant or someone under the tenant's control engages in the manufacture, distribution, or possession with intent to distribute a controlled substance in or around the premises, the landlord can terminate the rental agreement with a 7-day notice. The landlord doesn't need to wait for a criminal conviction. Evidence of the drug activity is sufficient to support the termination. Delaware also addresses situations involving violent criminal conduct. If a tenant commits or threatens violence against other residents, guests, or the landlord can pursue eviction on an expedited basis. Courts in Delaware take these situations seriously and will prioritize hearings when there's evidence of violent conduct. One aspect of Delaware law that landlords should understand is the state's approach to manufactured home communities. Delaware has a separate Manufactured Home Owners and Community Owners Act, Title 25, Chapter 70, that governs lease termination in mobile home parks. The rules for manufactured home lot rentals include longer notice periods and additional protections that differ from standard residential tenancies. Landlords who operate manufactured home communities in Delaware must follow the specific requirements of that statute. The eviction process in Delaware goes through the Justice of the Peace Court. The landlord files a complaint for summary possession, and the court issues a summons to the tenant. The hearing is typically scheduled within a few weeks of filing. Delaware's Justice of the Peace Court system is designed to handle landlord-tenant cases efficiently, and the process is relatively streamlined. At the hearing, the landlord presents evidence supporting the grounds for eviction. The tenant has the opportunity to respond and raise defenses. Delaware courts allow tenants to raise defenses including improper notice, the landlord's failure to maintain habitable conditions under Section 5305, retaliatory eviction, and discrimination. The habitability defense is significant in Delaware. If the tenant can demonstrate that the property has unresolved code violations or habitability defects that the landlord knew about, the court may deny the eviction or reduce the rent owed. If the court rules in the landlord's favor, a judgment for possession is entered. The tenant then has a specific period to vacate, typically determined by the court. If the tenant doesn't leave voluntarily, the landlord can request a writ of possession, and the constable carries out the physical eviction. The overall timeline from filing to removal is typically 3 to 6 weeks for uncontested cases. If the tenant appeals, the case moves to the Court of Common Pleas. During the appeal, the tenant may be required to post a bond or pay rent into the court to remain in possession. The appeals process can add several weeks to the timeline. Delaware allows the landlord to seek damages in the same eviction proceeding. This includes unpaid rent, property damage, late fees, and court costs. Combining the possession and damages claims in a single proceeding saves time and legal fees. On the tenant side, Delaware provides several grounds for early termination. If the landlord fails to maintain the property in habitable condition, as we covered in our Delaware habitability video, the tenant can provide notice and allow the landlord a reasonable time to make repairs. If the landlord doesn't act, the tenant can pursue remedies including lease termination under Section 5305. For essential services failures, meaning situations where the landlord's failure to maintain the property results in the loss of heat, running water, electricity, or other essential services, Delaware provides expedited remedies. The tenant can take more immediate action, including termination of the rental agreement when essential services are not restored within a reasonable time. Active duty military members are protected by the Service Members Civil Relief Act and can terminate with 30 days' notice following deployment or permanent change of station orders. Dover Air Force Base is Delaware's most prominent military installation, making this provision particularly relevant to tenants in the Dover area. Delaware provides early termination rights for victims of domestic violence, sexual offenses, and stalking under Section 5314. A tenant who is a victim can terminate the lease by providing written notice along with documentation, including a valid protective order, a police report, or a written statement from a qualified professional, such as a domestic violence counselor, social worker, or medical provider. The tenant must provide at least 30 days' notice before the termination date. The landlord cannot charge early termination fees, and the tenant's liability is limited to rent through the termination date plus any damages to the property. Delaware's domestic violence termination provision also includes a lock change right. The tenant can request that the landlord change the locks to exclude the perpetrator, and the landlord must comply within 48 hours of the request. The cost of the lock change can be charged to the tenant. Delaware also protects tenants from being evicted because of the domestic violence itself. A landlord cannot terminate a tenancy based on the tenant being a victim of domestic violence, and cannot use police calls or disturbances related to the domestic violence as grounds for eviction against the victim. Delaware strictly prohibits self-help evictions. Under Section 5313, landlords cannot change locks, shut off utilities, remove doors or windows, remove the tenant's belongings, or take any action to force a tenant out. The penalties include liability for actual damages and up to 3 months' rent or 3 times actual damages, whichever is greater, plus attorney's fees. Delaware's penalty structure makes self-help eviction financially devastating, and courts enforce this prohibition aggressively. Delaware's anti-retaliation protections are found in Section 5516. Landlords cannot increase rent, decrease services, or file for eviction in retaliation for a tenant making a good faith complaint about habitability to a government agency, complaining to the landlord about conditions, or exercising any right under the Landlord-Tenant Code. If adverse action is taken within 90 days of the tenant's protected activity, there is a rebuttable presumption of retaliation that the landlord must overcome. One practical consideration for Delaware landlords: the state's small size means that a limited number of courts handle the majority of landlord-tenant cases. Newcastle County, which includes Wilmington and the northern part of the state, has the highest volume of cases. Kent County, which includes Dover, and Sussex County, which covers the southern and beach areas, each have their own justice of the peace courts with their own practices. Familiarity with the specific court where your property is located helps you navigate the process efficiently. Delaware's coastal communities, particularly the Rehoboth Beach, Dewey Beach, and Bethany Beach areas, have a significant seasonal rental market. Short-term and seasonal leases have different termination dynamics than year-round rentals, and landlords in these areas need to understand how Delaware's Landlord-Tenant Code applies to seasonal tenancies. The code does apply to most residential rentals regardless of duration, so even short-term seasonal landlords must follow the statutory procedures. Delaware requires landlords to return the security deposit within 20 days of the tenant vacating the property. The landlord must provide an itemized list of any deductions. If the landlord fails to return the deposit or provide the itemization within 20 days, they may forfeit the right to retain any portion and could be liable for double the amount wrongfully withheld, plus attorney's fees. Delaware limits the security deposit to 1 month's rent for leases of 1 year or longer, and for shorter leases, the deposit cannot exceed the equivalent of 1 month's rent. These limits apply to the total of all deposits collected, including pet deposits and any other refundable deposits. For the complete guide to Delaware lease termination laws, visit tenantscreeningbackgroundcheck.com and subscribe to our channel for every state in our series.